Philip is a partner at a local firm here called Godfreys Law. He's been practicing here in Christchurch for over 30 years, and he's quite well known. I can't seem to swing a cat without hitting someone who's come across Philip, and they all speak very highly of him, both in terms of his technical abilities and just being a nice guy. Philip's going to be talking about giving with a warm hand. And I won't ruin any more of it. Philip, I'll let you take it away.
Great, thanks, Sonny. It's a great build-up too, thanks for that. So giving with a warm hand, the distinction here being from giving while you're alive, as distinct from giving when you're dead, giving under your will. I'm pretty keen on people giving while they're alive. There are quite a few advantages. The good aspects are things like your enjoyment of seeing the money well applied. There's a possibility that you might have some influence or control over how that money is applied. Often it's given at a good time in that person's life, rather than wait till a parent dies, which could be many years down the track. Money coming in at that time, late in life, for the recipient, not quite so useful as getting it earlier in life. So lots of good things about giving with a warm hand, giving while you're alive. There are some worrying aspects, as I'll show on the next slide. So when you give your money away, and we'll just click down a bit more. So when you give your money away, there is a risk that there will be poor decisions by the donee. And there's also the risk of what I call profligate spending. I think that's the right term. And of course, that's a generational thing. What one generation thinks is profligate spending, another thinks is perfectly in order. And I suppose an example of that is what my 90-year-old mother thinks of me and how much wine I drink. She probably thinks I'm a bit of a profligate and she'd rather not give money to support that. I think it's just about the right amount. Another worrying aspect is the risk of relationship failure, and that's one of the big ones I'll be talking about today in the context of this discussion of gifting. So the problem here is, and this is, everyone knows this, it's the idea that if you make a large gift to young people, and we're talking gifts within families principally, if that relationship fails, then the ex-partner, the ex-spouse, in effect walks away with half that gift. So it's something we've all encountered quite a bit. There are some well-known ways of trying to deal with it, and we'll come to those shortly. The next one mentions not getting money repaid, but we'll skip over that. After that, a worrying aspect is to do with possible problems with residential care subsidy applications later. And many of you will remember the gifting that we did in the late 90s and early 2000s when forming family trusts was the thing to do. And we had gifting programs that ran for many years. We were gifting away $27,000 per person, so $54,000 each year. Seemed the right thing at the time. And then, of course, in 2005, the government did raise the threshold, but they also brought in the idea of excess gifting or deprivation. So as from 2005, gifts in excess of $27,000 per couple cause problems if you later wanted to get that subsidy. So what it means, of course, is that the gifting that many of our clients and maybe some of us did in those years, they are now causing a problem if you are trying to fit the eligibility criteria. Those gifts are often counted back now as excess gifting. You thought you'd gifted it away, but it's counted back as another asset. So on the next slide, I talk about acknowledgments of debt. Now, of course, this is used a lot now where large sums of money have been given to family members. And typically we see these in the context of buying a first home. With the minimum deposit requirements now, we all know it's hard for young people to get housed. And this is where the bank of mum and dad comes in. Maybe the bank, it might be a bank, it might be a loan, maybe it's a gift. I think with many families, they'd like to gift it. Some like to have it as an acknowledgement of debt. My experience is that because of the risk of relationship failure, the acknowledgement of debt, if the lender will wear it, is the one to try. Now, some lenders get a bit hooked up on borrowers signing more debt. And so you've got to be careful, and the best solution is one which involves the mortgage broker as well as the lawyer. So you can see the sort of things that I think should be in an acknowledgement of debt. You want both parties, both the borrowers, to sign, not just your child. There should be no repayments. That's the biggie for the lender. They want to know that the ability to service is not compromised by a family loan in the background. Interest-free, of course, and it's important to record that it is to be repaid on sale. Lawyers are very keen on saying things are repayable upon demand, whatever that means, but it needs to be clearly stated if this property for which we're advancing a large sum of money is sold well, you can pay it back. The ability to register a caveat, that's not a necessity, but quite a nice idea just in case there is a falling out between the person advancing the money and those using it, and in case there's some disagreement over whether it's repaid or not. So in my view, an acknowledgement of debt like that is a better way than a gift. We talk about gifting with a warm hand, great in some cases. For young people buying a house and a new relationship, not so good. So an acknowledgement of debt on these terms is worth trying, worth putting to the mortgage broker so he can try it out with the lender. But often the lenders might create problems. They might require a declaration of gift, and that can create issues. My next slide talks about another idea which I personally am quite keen on, the idea that a simple contracting out agreement, lawyers call it a Section 21 agreement, it's an agreement under the Property Relationships Act. Now, we've seen lots of these agreements, and they're typically used, Section 21 agreements, when relationships fail, but also for contracting out. So my idea is that where a young couple are putting in roughly equal amounts of money, there's no need for an agreement like that. But if, say, it's your daughter and you're lending or gifting, say, a large sum, say another $75,000 over and above what the other two are putting in, my view is that a simple contracting out agreement can give some protection. And the essence of this is that if they split up, that $75,000 is to be repaid to the daughter before anything else is halved 50-50. And as you know, it's the 50-50 rule in relation to the family home that causes the problem. That's where the ex gets to walk off with half the gift. So a few drop-down points on this one. It's only appropriate in some